Hi, I'm Diana Schwartz. I am a Senior Associate at PPM Attorneys, and today we are going to be discussing the prosecution of social media offenders. With the rise of bullying and cyberbullying incidents at schools and outside of schools being reported in the media, pertinent questions in relation to the prosecution of social media offenders have surfaced. So, how does the prosecution of social media offenders work? Children from the ages of 11 to 18 up until 18 are deemed to be legally liable for their actions and can be sued for defamation civilly, for assault or criminal injury criminally. Children from 11 years of age and up to 14 years of age have criminal capacity, and the onus to prove that criminal capacity rests on the state. Children above 14 years of age have criminal capacity unless otherwise proven by the accused child. Another legal remedy available to the victim of a social media infringement is obtaining a protection order in terms of the Protection from Harassment Act of 2011. The Act provides that someone who has been bullied can ask the courts for an interim protection order, which will be granted as long as the court is satisfied the respondent has harassed or is harassing the applicant and that harm has or may be caused. The interim order can be granted without the respondent's knowledge, as forewarning may undermine the point of the protection order, and children under 18 can approach the courts without their parents' knowledge. Insofar as minimum and maximum sentences go, in every matter concerning a child, his or her interests are of primary importance. The detention of a child should only be considered as a last resort and then for the shortest possible period. If a child is detained, he or she must be kept separately from other detained persons over the age of 18 years and held in the same holding cells as his or her own sex, and has the right to be treated and kept in conditions that are suitable for his or her age. A well-known case of cyberbullying includes that of Keely Houghton. In August 2009 in the UK, Keely Houghton, who was 18 years old, was sentenced to 3 months imprisonment after pleading guilty to harassment. She had cyberbullied another 18-year-old girl for 4 years and threatened to kill her. Keely was the first person in Britain to be sent to prison for cyberbullying. Whether it is a civil or criminal case depends on the action the victim wants to take. If it is criminal injury, which is unlawfully, intentionally, and seriously impairing the dignity of another, such as stalking, emotional or psychological abuse, or assault, this is a criminal matter, and once charges are pressed, the state will prosecute. If the victim wishes to sue the perpetrator for defamation, this would be a civil claim, and the victim would need to be represented by an attorney unless the work was done pro bono. Private funds would be needed for civil action unless it is pro bono. In respect of filming of bullying incidents or videos, any person who filmed the bullying incident for the purposes of publicly publishing the video could also be sued for defamation civilly or criminal injury criminally. There would be no liability for the person filming the bullying incident for the purposes of obtaining evidence against the bully. Any persons responsible for distributing the video on any platform, provided it is a public platform, can be sued for defamation if the video contains untrue statements about the victim. Defamation is the wrongful and intentional publication of defamatory words or conduct that refers to another person. The common law elements of the delict of defamation are the wrongful and intentional publication of a defamatory statement concerning another person. The publication of this video, including sharing and retweeting, falls under this definition. Even if a person simply shares or retweets the video but was not the original poster of the video, can be sued for defamation, as they are responsible for the publication of the defamatory material. The person who distributes the video can also be charged with criminal injury, as distributing the video impairs the dignity of the victim. If the video goes viral, this will be taken into account by the courts. The further the reach, the more damage is caused. That is, a video that is distributed amongst a class versus thousands on social media and the media itself. People may be prosecuted for seeing an online video of minors in a bullying incident and sharing it on their social media platforms. However, this depends on the circumstances. Technically, there is liability for publishing defamatory material and material that can impair a person's dignity. The intention behind sharing the video would be weighed up. However, the victim is entitled to take action against anyone spreading the video. So, what should we do if we see a video involving minors in a bullying situation? The video should be reported to the online service provider on which it is being distributed and requested that the video be removed. The person responsible for distributing the video must as far as possible be made known to the platform. Most online service providers now have specific security and cyberbullying settings in which to report these incidents or content. So, how do you protect yourself against a case of defamation? Unfortunately, there is not much one can do, except to immediately remove the post and apologize to the victim, and hope the victim will not sue for defamation. The most important thing to do is do not post, share or retweet information or content that could be defamatory and could infringe upon the rights of others, especially children.